So, ma'am, today we will study lesson number 5, legal reasoning. Ma'am, what we will study in this chapter? In this chapter, we will study about lot of legal maxims. Legal maxim means legal terms, Latin terms which are used in law, which are used in courts, legal proceedings, which are used to interpret law. So there are various legal terms, legal terminologies, which have some different law meanings, which have some specific meaning in the law, which are used in legal proceedings in order to interpret acts, rules, regulation, which are used in the court of law. Right, so we are going to study about a lot of legal maxims here. Ma'am, some of the legal maxims are already being covered in few chapters, like Indian Contract Act, Law of Torts, uh, Constitution of India, or your company law chapter. So I will not cover those legal maxims which are already being covered in Constitution of India, Contract Act, Law of Torts. Why? Because I have already taught those legal maxims. So this yellow ones are already covered earlier one day. Remember, I covered some of the legal maxim which we have already studied in other chapters. So I will not cover those legal maxim which we have already covered in other chapters, Contract Act, Constitution, company law. I will cover remaining legal maxim which we have not studied in any of those previous chapters. Okay, yes. So ma'am, there are lots of legal terms are given here which you will study for the first time. And you know what, in this chapter some of the legal terminologies are so complicated that they are not even used in corporate law, they are used in civil and criminal cases. Like there are few terms which are specifically used in courts, which are used by judges, which are used in interpreting civil and criminal laws, which are not relevant for corporate law. But still, since this is given in your syllabus, so we have to study. Don't take too much headache of this chapter. Learn as many legal maxims as you can. If you can't, you can skip few. Don't take too much headache. Keep this in last priority, means first complete other syllabus. After that, if at last time is left, then take headache of this chapter. Otherwise, don't take headache of this chapter. Like why I left this chapter for last? Because I knew I cannot skip this. I cannot skip other important chapters of communication for this chapter. So that is why I kept it for last. Ki let's cover important thing first. Let's cover the important chapters of communication 4, 5, 6, 7. Let's cover the environment syllabus first, and then at last we will have an overview of this chapter according to the priority. It's important to give priority. So don't just start mugging up all the legal maxim if you have lack of time. First give priority to your other subjects, to your other chapters of legal aptitude, like Contract Act, Constitution is very important, Contract Act is very important. Give importance to all this chapter. Once you are done with the other syllabus, then you can just go through the legal maxim once. If you're not able to understand a legal maxim, you can keep it at a bay, means you can keep it at last option for a while, that if at last you will get time, then you can refer those. Otherwise, don't take much headache. Anyways, one or two legal maxim will come. For that, we have to study 5 pages legal maxim, like almost 100 200 legal maxims, right? So take it very lightly, take it very lightly. Try to understand as many legal maxim as you can. Take it very lightly, don't take too much headache of this chapter. Okay, so with this, we will start with this legal maxim chapter, where one by one we will try to understand different terms, legal terms. Okay, keep patience. Lot of new words. Trust me, lot of new words you are gonna face. So keep patience. Be very cool. Be very chill, and take it very lightly. Okay, don't take headache. Oh my God, what is this? Oh my God, what is this? When we learn something new, you have to keep patience. So starting with few legal terminologies. The first legal terminology that we have to learn is a priori. What do you mean by a priori? A priori means when you decide something based on your earlier experience, when you make a conclusion, when you derive to a conclusion from earlier experience, when you reach to a consequent from antecedent. Antecedent means earlier, consequent means which you have derived later. So when you reach to a consequence from the precedent, from the antecedent, that is a priori. From the antecedent to consequent means which you deduce, which you decide based on earlier experience, based on earlier experiences, something which we assume without giving a logical analysis to it, that is a priori. A priori means when we reach to a conclusion based on the antecedent, based on the earlier experiences, that's a priori. Ab initio we have already studied. Void, ab initio, from void, from the very beginning. Ab initio means from the very starting, from the very beginning. We have already studied this in Indian Contract Act. After that, the next legal maxim is your absolute sententia expositor non indigent. What do you mean by absolute sententia expositor non indigent? It means plain words which require no experience. Sometimes law is very clear, like a public company is a company which is not a private company. It is very clear. Sometimes law is very clear, for which no explanation is required. So if court made any judgment, court made any statement, or there is any law, there is any word which meaning is very clear, which requires no further explanation, that is known as absolute sentence. Yeah, absolute means clear sentence. Sententia means sentence. Absolute sentence. Expositor non-indigent means no explanation required. Next is actio mixta. See, sometimes the name itself suggests the meaning. Actio means action. Mixta means mixed. Actio mixta means mixed action. Acha, this PDF I will send you, don't worry. The meanings which I have written, I have done a lot of research for this chapter. Yeah, to understand, there are few terms which I even didn't know, so I have to research about that word. Bro, what does this word mean? I did a research, I learned about those words, I learned some of the judgments, some law, some court judgments to understand those particular words. So a lot of efforts has been required for this chapter. So this PDF I will send you, don't worry. Actio mixta. Actio mixta means mixed action. Sometimes when you file a case to the court for getting a relief, so when you want one single relief, that is single action. Mixed action means when you want multiple relief, especially when you file a criminal case as well as a civil case. Let's say let's say somebody has done defamation. Defamation is a civil act, a civil wrong as well as criminal wrong. So I can file a civil case as well as criminal case. So here for the civil case I get damages, for criminal case I get penalty. So when you uh, file a suit in the court for getting multiple remedies, for getting damages also, for getting penalty also, that is actio mixtia. When you're filing a case for getting multiple remedies, which means you are taking mixed action, you are taking civil action also, you are taking criminal action also, that is actio mixtia, which means mixed action. Yes, are we clear with this? I will just go, I will keep on going because time is less, and there are a lot of legal maxims, so in case you are not able to understand any particular legal maxim, you can just put it in the chat box. I will take up that legal maxim again. In case you don't understand any legal maxim, feel free to put it in the chat box. Okay, unless if you won't put any legal maxim in the chat box, I will assume that you have understood. Next is actio personalis moritum cum persona. What do you mean by actio personalis moritur cum persona? Means a personal right of action dies with a person. Let's say somebody has slapped me, so I have right to take action against Mr. A. Mr. A has slapped me. If Mr. A will die, my right to take action will die because Mr. A has died. So my right to, now I cannot file a suit against Mr. B. He hasn't slapped me, Mr. A has slapped me. So whenever there is any personal wrong done, somebody has done any personal wrong with me, so if that person dies, I cannot take, my right to take legal action also dies. My right to take legal action also dies. So if the either party dies, let's say Mr. A slapped Mr. B, if Mr. B dies, then in that case, that right to take action also dies along with him. In very few circumstances, even a legal heir can take action after death. But there are some personal cases where if you die, only you had right to take action. So if you die, that right to take action also dies along with you. That is known as a personal right of action dies along with the person. Example, defamation. Example, defamation means, let's say Mr. A said bad words about Mr. B. Mr. A said something against the reputation of Mr. B. So if Mr. A will die, Mr. A will die, Mr. B right to take Mr. B's right to take action will also die. Are you understanding here? Actio means action, personalis moritur cum persona. Persona means against person. So your personal right to take action will die along with the person. Next is actionable per se. Actionable per se means some actions which are itself some accident or some act which are itself punishable, against which you can take action even if there is no damage, even if there is no actual damage. It is actionable per se means by itself, if that action, if that accident has happened, by itself you can take action without proving anything, without proving any actual damage. Example, trespass. Example, trespass. If somebody has trespassed into your house, just because trespass has happened, you have right to take action. No need to prove whether there is actual damage or not, whether he actually stole some property from your house or not, whether you actually suffered damage or not. Even if there is no actual damage, then also that trespass is actionable per se. Trespass is actionable per se. It means if somebody has trespassed you, just because trespass has happened, you have right to take action. You have right to take action against that. No need to prove actual damage. It is itself actionable. It is by that action itself, by that situation itself, you can take action. That is actionable per se. If injury is there, actual damage is not required. Example, plaintiff can claim compensation even if there is no actual loss. Example, trespass. Yes, the very act is punishable. No proof of damage is required. Actionable per se means the act which is by itself punishable. No need to prove actual damage. Trespass is itself permissible, punishable. Trespass is itself punishable. No need to prove actual damage. Next is actus curiae naminem gravebit. What do you mean by um, actus curiae naminem gravavit? See, this is a very specific legal term. Like if I'll go on explaining, I can explain you an hour on this particular maxim, but I can't invest that time in this particular maxim because it will be illogical. It is not of that much weightage in your exam, so I have to explain you in very brief, and that's a real challenge. See, actus curiae naminem gravavit means sometimes court give wrong judgment, and because of the wrong judgment of the court, a innocent party has to suffer, right? So sometimes court also give wrong judgment sometimes. So when sometimes court give wrong judgment, and because of that innocent party suffers, so court has to undo that judgment. It is a responsibility of court to undo that judgment so that innocent party does not suffer, so that it does not prejudice an innocent person, so that it do not prejudice a person. So court, because of court, nobody should suffer. So the act of the court should not prejudice any person. The action of the court should not be against any innocent person. So that means actus curiae means act of the court. Actus means act. Act of the court. Curiae means court. Act of the court should not prejudice anyone. Should not prejudice anyone. Are we clear with this? And if because of court any innocent person has suffered, then court has to undo that judgment. Why? Because on the basis of actus curiae naminem gravavit, act of the court should not prejudice any person. That is actus curiae naminem gravavit. Now, ma'am, this from here to here we have already covered in law of torts and Indian contract act. This we have already covered in law of tort. Actus rea means wrongful act, actus means act, rea means wrong, actus non facit, reminis mens sit rea means act does not make a man guilty unless there is a guilty intention. Remember, in order to make an act wrong, there should be guilty intention, there should be mens rea, there should be guilty mind. Ad hoc means when something is very sudden on the basis of particular case, on the basis of particular end for a particular case. Ad hoc, ad idem, at the same point. Consensus ad idem, meeting of minds at the same time, at the same point of time. Ad idem means at the same point. Ad valorem means according to value. Stamp value is ad valorem, means stamp duty is ad valorem, means stamp duty is levied according to the value of transaction. So ad valorem means according to the value. We have already covered this, even though I have explained again. Okay, if you want me to explain in detail, you can message me over Telegram. I'll explain you. Eliande. Eliande means from another source. From another source means sometimes for giving a judgment, court is referring to a document. But if we refer to some other document or some other source to give a judgment, that is known as aliende, means from another source. From another source, aliende means from another source. It means evidence may be considered, like is it necessary to consider the evidence only from the main document which you are referring? No. Court, while considering a case, while hearing a case, court can, along with the main document, can also refer any other source or any other document for admitting as an evidence, that is known as aliende. Aliende means from another source, evidence may be considered from any other source rather than the main document under consideration. So if we consider evidence from any other source apart from the main document, that is known as aliende. Means when you are taking evidence from any other document, from any other source, when court is taking evidence from any other document, from any other source, that is aliende. Next is amicus curiae. Amicus curiae means sometimes court ask expert advice. Expert, like KBC, expert advice, kaun badega crorepati, they take expert advice. Court also sometimes take expert advice. There are proper lawyers and people who are appointed to give advice to court. So when court take advice from an independent person who's neither related to plaintiff nor related to defendant, because obviously if you are taking expert advice, he should not be related to both the parties, otherwise he will become biased. So we take a court take opinion from independent or expert person who's not related to plaintiff or defendant to give opinion to the court. He is known as friend of the court. Friend of the court, he is known as amicus curiae. Amicus curiae, amicus curiae means a friend of the court, member of the bar, who is appointed to assist court, to give opinion to court. Assist means to help court. He is independent expert person, not related to plaintiff or defendant, to give opinions to court. That person is known as amicus curiae. Yes. Moving forward, animus possidendi. Animus possidendi. Don't focus on writing, focus on understanding. Now I will send you this PDF. You can take a printout, 4 pages only it is. You can take a printout. Your writing efforts will be saved. Okay. Animus possidendi means intention to possess, which means that if I say uh, this phone is mine, if I say this phone is mine, if I am showing this property is mine, then two things are necessary. First, physical possession is necessary. Physical possession means physically I should be holding this phone, physically this phone should be in my possession, and I should also have intention to possess it. Intention to possess means I am possessing this phone intently because this is my phone, I have intention to possess it. Then only it shows your right of ownership. Example, I came to this studio and suddenly I saw this phone lying here in the table. It was not my phone. I'm telling you, it was not my phone. I came to my home. Suddenly, I don't know who kept this phone. Suddenly, I saw this phone kept in a table. It is in my possession, yes. Since it's in my room, it's in my home, it's in my room, is it in my possession? Yes. But do I have intention to possess it? No, 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 no. I don't have intention to possess it. I don't know who kept this phone here. I don't know who kept this phone here, which means I did not intend to possess it, even if it's in my actual possession. So is this property mine? No, this property is not mine. So in order to claim an exclusive right over a property, both physical possession and intention to possession is required, and that intention to possess is known as animus possidendi. Yes, clear? Animus possidendi means intention to possess. If you are actually possessing something, are you also having intention to possess it? Yes, that is animus possidendi. Next is audi ultram partem. Audi ultram partem means here the other side. You cannot give a decision like court. This is applicable for court proceeding. Court cannot give an order without giving opportunity to the other party. Like if plaintiff is making some accusations on the defendant, court cannot just give order just by hearing the plaintiff. Court also has to hear to the defendant side, and we also have to give opportunity to the defendant that do you want to say anything, do you want to give any clarification. That is known as audi ultram partem, means here the other side, here the other side. Every party should be given opportunity to respond to evidence against them. No party should be judged without fair hearing. Have you seen in movies that whenever evidence is presented in the court and then judge asks the defendant that do you want to say anything against this evidence? So we have to give opportunity. The court has to give opportunity to both the parties to respond against the evidence. So court is giving opportunity for you to speak against evidence, against your evidence, that is known as audi ultram partem. Yes, clear? Okay, this yellow portion we have already done in our previous class. Benami means nameless, bona fide means in good sense, in good faith. Caveat emptor means let the buyer beware. Caveat actor means let the doer beware. Caveat seller means let the seller beware. Certiorari we have already done in writ petition constitution of India. Consensus ad item we have already done, means meeting of minds at the same time, in the same sense, meeting of minds. This yellow highlighted words are already covered in the previous lectures. These are already covered in Constitution of India and Indian Contract Act. Now ma'am, this blue word is not covered. Caveat. Caveat means beware. See, caveat emptor, emptor means buyer, so caveat emptor means let the buyer beware. Like when you see the expiry date before buying anything, so why? Because caveat emptor, let the buyer beware. So caveat means beware. Caveat, what is the dictionary meaning of caveat? The general meaning of caveat is beware. Now this is a proper legal term. I'll explain you what does this mean. See, sometimes when I have a prediction that this person now is going to file a case against me. When I have this apprehension that he might file case against me, he's going to file case against me, so as a precaution, as an awareness, what I don't want court to admit that case. If I have an intention, I have got apprehension that Mr. A is going to file case against me, and I'm pretty sure that case is not a valid case. He is filing a very time pass case against me. That case is not a valid case. So, as a caution, like as a precaution, what I can do, I can file a document to court. I can ask court, Mr. A might file case against me with you, and in case Mr. A files case against me, you don't accept the case without giving me notice. You first give me notice. You first give me notice. Listen to my part also. Then accept case, then take any action. Without giving me notice, you cannot take any action. So here you are being precautious. You are taking precaution from advance. If you know that this person might file case against you, you can file a document to court. By that document, you are asking court to 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 give you notice. If anyone files case against you, then you ask court to give you notice before taking any action, or before giving any relief to the other party. That is caveat. What is caveat? Caveat means a caution which is registered with the public court. A caution, a precaution, it is like a precaution. So if I has an apprehension that somebody can file a case against me, I can submit a document that is known as caveat. I can submit a caveat to the court. So it is like a caution which is registered with the public court to indicate that the court officials, that they are not to act in a matter mentioned in the caveat. Do not act, do not accept the case, do not act on this matter without first giving notice to the caveator. Caveator means a person who's filing caveat. I am filing caveat to the court, then I am caveator. And I am asking court to first give notice to me. So here you submit a caveat to the court, that they should not take any action, they should not act without first giving notice to the caveator. Are we clear with this? Yes. Okay, so applicant request court. Applicant means if I am filing caveat to the court, I am applicant, and I am also caveator. Applicant requests the court not to give any relief to other party or to take any action without giving notice to the applicant. Yes. Are we clear with this? Next is Sestui Q trust. I might be wrong in the pronunciation, but yeah, go with the meaning, don't go with the pronunciation in this chapter. Sestui Q trust. What does this mean? The trust concept of trust. Example I gave, that Amitabh Bachchan example. Amitabh Bachchan kept his property in trust for the benefit of his granddaughter Aradhya. So here, whosoever is a beneficiary under a trust, that person is known as beneficiary, and that person is known as Sestui Q trust. Sestui Q trust means beneficiary under trust, a person who's beneficiary under a trust. So Amitabh Bachchan gave his property with a trust for the benefit of Aradhya. So here Aradhya is the beneficiary of a trust. She is beneficiary under that property, or she is beneficiary of that property under a trust. She is known as Sestui Q trust. Next is contemporanea expositio est optima et fortissima lege. Don't panic. Be very chill. I'm telling you, you are gonna hear lot of new legal maxim. Be very chill, be very cool, take it very lightly. Okay, take a chill pill. So contemporanea expositio est optima et fortissima lege. Wow, it's like a whole country's name of countries of whole world. So long, so long. Okay, what does this mean? This means historical, uh, let's say, how do you interpret, I'm giving you example. Okay, how do you interpret constitution was made in 1950. Me, who was the major draft person of the constitution? B.R. Ambedkar, Dr. B.R. Ambedkar. So if I tell you today, if we have a confusion in particular article, what does article 29 means? So if let's say we have a confusion in understanding a particular article, if we have confusion in understanding a particular article of a constitution, if we have confusion in understanding a particular law, what is the best way to understand a law? Go to the intention of the lawmaker, that by which intention, by what intention B.R. Ambedkar made this law. By what intention, what was the intention of the lawmaker when they made this law, when they made with this law. So you go to the historical meaning, you go to the historical meaning in order to derive the proper meaning of a law. When you are confused about a law, that is known as contemporanea expositio est optima et fortissima lege. Are we clear with this? Yes, it means a contemporaneous exposition. Contemporaneous means historical or old, historical or old. Contemporaneous exposition or language is the best and strongest is law. Means in order to understand law, what is the best way to interpret a law, what is the best way to construe a law, is to read it as it was read when made. You interpret it the way it was interpreted when it was made. You go to the historical meaning, you go to the historical meaning, so that you will be able to understand the meaning of that law in a proper manner. Yes, are we clear with this? Yes, this is this particular term. With this we are done with one page. Congratulations. Moving towards next page. Corpus delicti. Easy. Corpus delicti means body of the offense, which means a person cannot be put on a trial for crime unless and until the crime is proven. Which means that if somebody is saying that simply somebody is saying, let's say this happens with us mostly. Let's say your 500 rupees money got lost. You lost your 500 rupees. We automatically get apprehension. My roommate has stolen it, this person has stolen it, this person has stolen it. You just think on yourself, and let's say you went to police station and you put an FIR. This person has stolen my 500 rupees. Bro, it's not even sure that it's stolen or not. It's not even sure. You might have lost your 500 rupees, so, or you might have kept it somewhere and you forgot it. So it's not even sure that Mr. A has stolen your 500 rupees. And you went to the court, you made an FIR, you registered an FIR that this person has stolen. Will court register this case? No. Court will ask other person, and your neighbors, let's say court asked your neighbors, and your neighbor said that no, Ishika has the habit of forgetting things. She might have kept this 500 rupees here and there, and she has forgotten it. It's not necessary that Mr. A has stolen. So here even crime is not proved. So you cannot put Mr. A into trial. You cannot put Mr. A behind the bars. Okay. So corpus delicti means offense should be there in order to start legal action. At least offense should be proved that yeah, offense happened. Here it's not even proved that yeah, he stole, stealing has been done. It's not even sure that stealing has been done. It might be possible that I have kept my 500 rupees somewhere and I have forgotten it. So the crime is not yet proven, so court will not entertain it, and person cannot be put into trial. That is corpus delicti, means there should be offense should be proved in order to start a trial. Body of offense. Corpus delicti means body of offense, which means person cannot be put into a trial unless and until the crime is proven, that yeah, crime has actually happened. Next is cypress. Cypress means as nearly may be practicable. See, practicable. Sometimes it's not possible to do everything 100%. 100%. So what we say, okay, somewhat here and there will also be acceptable. That is Cypress. Cypress means even if you are not able to do it 100%, you are able to do it 80%. We will consider it. We will consider it as nearly as may be practicable. That is Cypress. Example, let's say you made a charitable institution and you said that okay, we will donate, we will do 100% charity. And let's say you took a task that we will do this, we will do this task, we will do this, we will do this charity, we will donate 100 crore into this, into that. And let's say you are not able to complete that task, you are able to do that 70% or 80%. Will court say that you did not do your charity and court will reject your license? In order to do charity or make a charity company, you have to take license from government, right? So can court say that no, you have not done charity and your license is cancelled? No, here court will apply the concept of Cypress, that okay, even a bit here and there, it is near to the main goal, it is near, then okay, court will accept it. If it is practicable, court will accept it. So as nearly as may be practicable means Cypress. This is applied by courts while giving judgments, so what is Cypress means as nearly as may be practicable. It is usually used by court for interpreting, example, for interpreting will, gift, charitable trust, etc. Example, one example, the same example which I gave you, even if 60% work is done, the court will consider the work done by applying the concept of Cypress. Are we clear with this? Cypress, yes. These two words we have already done earlier. Damnum sine injuria, injuria sine damnum. Ma'am, we studied this in very detail in law of torts. Damnum sine injuria means damage without injury. Injuria sine damnum means injury without damage. De facto means in fact, something which is factually right. In fact, this we have already done. De jure. De jure means which is according to the law, which has been given legal recognition, even though if it not exists in reality. See, sometimes we do some things which are not legally recognized, but they are not illegal also. When we do something which is not legally recognized but which is not illegal also, we do it in real situation, in reality, that is in fact. And there are some things which are permissible in law, which are given in law, but in reality it does not exist. That is de jure. De jure means that right is given in law, that right or that is permitted in law, legal recognition is given in law. Act which are legally recognized whether or not they exist in reality. There are some acts which are legally recognized even if it does not exist in reality. That is de jure. Next is de horse. De horse means not that horse. De horse means something which is foreign, not related to. So let's say you make a statement or a quote, consider a document which is not related to the main document, or you make a statement which is not related to the case. Any statement or any particular thing which is not related to the case. See, these are legal terms. Okay, so de horse means something which is not related to us, which is not related to the case, which is unrelated, which has no connection with the case, which means which is foreign. That is de horse. De horse means outside or foreign to, unconnected with, or unrelated to. De novo. Novo means new. De novo means to make something new, to start it from the very beginning. See, sometimes what happens, let's say you file a case in district court. District court gave a decision which was not right. So you will file appeal against the judgment of district court to high court. And if high court thinks that the judgment of district court is wrong, the judgment of district court is inappropriate, then high court will not consider the judgment of district court. It will start the case from the very beginning. So that is de novo. De novo means it will make the case new and it will consider the case from the very beginning. It will not consider the judgment already given by the lower court. That is de novo, to make something new. New. Novo. De novo means to make something new. That is to start it from the very beginning. Example, appeal in court. Appeal in court means higher court in which you file appeal. Appeal in court, it feels that lower court decision is inappropriate, then it takes up the case de novo, which means it starts the case from the very beginning. It deals with the case from the very beginning. That is de novo. Are we clear with this? Yes. Okay, next is Dies nos means days on which work is not performed, unauthorized absence. When you take absence without taking leave, without authorizing, without authority, without taking permission, when you take leave, that is known as dies non. Dies means day. Dies here means day. In Latin, dies means day. This is a very easy term, days on which action is not performed. Next is deceit. Your intention should not be to deceit. Deceit means when I want to do fraud with another person, I want to mislead another person, I am lying or I am making any false statement, or I am concealing the truth to mislead that another person. When your intention is wrong, that is to say deceive. When your intention is to do wrong with someone else, when your intention is to do fraud with someone else, to mislead another person, we say your intention is to deceit. Deceit means anything which is with the intention to mislead other. Intention is important here. Your intention should be to mislead another person, that is deceit. Del creditor agent, madam, have we heard this word? Del creditor agent? Yes, in Contract Act, in Indian Contract Act, we have studied del creditor agent. Basically, an agent who purchase and sell your goods on your behalf. That is agent. What do you mean by del creditor? Del creditor means he also takes responsibility to bear the loss in case he sells goods on credit and the debtor does not make the payment. He takes the responsibility to bear the loss. That person is known as del creditor agent, and in return of giving a guarantee, he demands some extra remuneration, that is known as del creditor commission. Okay, some extra commission, that extra commission is known as del creditor commission. That agent is known as del creditor agent. We have already covered this in Contract Act. Next is delegate, potestas, non potest delegaire. We have studied this. Kya? Don't remember? Sub agent. Acha, I will show you. Now remember, delegatus non potest delegare, which means a delegate cannot further delegate, which means your agent cannot make further sub agent unless and until he is permitted by the main principal. If I have allotted some tasks to Sohan, Sohan cannot allot that task to Vega without my permission. So a delegate cannot further delegate. That is meant by delegatus non potest delegare. So here, if you will come to this second particular term, delegatus non potest delegare means a delegate cannot further delegate, and same similar meaning the upper maxim have. Delegate potestus non potest delegare means a delegated power cannot be further delegated. Same thing here. We are talking about the person, here we are talking about the power. A delegate person cannot further delegate, and this means a power which is delegated to me, I cannot delegate that further. A delegated power cannot be further delegated. We have also covered these two terms in Indian Contract Act, ICA. Next is dictum. Dictum means statement made by a judge. Dictation, statement which is made by a judge. An opinion or suggestion made by a judge is known as dictum. So, statement made by judge. Statement made by the judge. Statement made by the judge is known as dictum. It may not be the final decision, but it is the opinions or suggestions made by the court. See, court, judge does not only give the final decision, it also give a long judgment. If you have, you read, have you seen court judgment? It is 100 pager, 500 pager. Court judgment is 500 pager. So it does not only give the main decision, it gives some opinion also, suggestion also. So any other statement made by the judge which is not the main decision, rather the opinion or suggestion of the court, that statement made by the judge is known as dictum. Dictum means the statement made by the judge. Dictum means statement made by the judge. Dispono means order. Something which is So, when you are giving order legally or when you are conveying something legally, that is known as dispono. Means to give order or to convey something legally, to give order. Dispono. Adjust dem generis. Adjust dem generis, this is one of the very important rule. This you will study in executive also, in JIGL subject. In executive you will come across this word, adjust dem generis. What do you mean by adjust dem generis? Adjust dem generis means when you use some specific word and then after those specific word you use some general words, then how would you interpret the meaning of that general word? The meaning of the general word should be related to the specific word. This not understood, don't worry, I'll give you example, now you will understand. If I say you motorcycle, truck, bus and other vehicles. If I say you motorcycle, truck, bus and other vehicles, here motorcycle is very specific word, truck is very specific word, bus is very specific word, but vehicles, other vehicles is a general word. Now tell me which all vehicle will come under other vehicles. Can ship come under other vehicle? Can aeroplane come under other vehicle? Yes, generally you will say no. But when you apply the principle of aegis dem generis, it says that when you are using any specific words, motorcycle, truck, bus are specific words. When you use any specific words, and if after those specific words you use any general word, then that general word should be interpreted in relation to the specific word. So here the meaning of other vehicle should be interpreted as the similar words like motorcycle, truck, bus. What is the common thing among motorcycle, truck, bus? Motorcycle, truck, bus, all three vehicles run in a road. So these are specific vehicles which are operated in a road, which run in a road, not in water or air. It runs in a road. So here other vehicles also include those vehicles which we drive in a road. Example car, example tempo, example cycle, right? Other vehicles which we run in a road. Here ship will not come, aeroplane will not come, because aeroplane flies in air, ship is operated in a water. So here, are you understanding what is aegis dem generis? Aegis dem generis means when you use any specific words, and if after those specific words you use any general word, then the meaning of that general word should be interpreted in relation to the specific word. Are we clear with this? Are we clear with this? Yes. If I say pen, pencil and other, so here other, what does other means? Bottle. What does other means? Musical instrument? No. If I say pen, pencil and other, then this other should be interpreted in relation to pen, pencil. What is pen, pencil? Stationery. So in other, what? Highlighter, eraser, sharpener, scale, all this will come under. Are you understanding? The if after specific words, general words is used, you have to interpret that general word in relation to a specific word. That is meant by aegis dem generis. Yes, clear? Okay. Moving forward, see here, adjacent genders, where any general words follow specific words, then those specific general words should be confined to the things of the same kind with that of specific words. Yes. Next is estoppel. We have already done estoppel. Estoppel means to stop from denying. Stop from denying. You will be stopped from denying that you are agent. That is agency by estoppel. Estoppel, you will be stopped from denying. We have already covered this in Indian Contract Act. Ex parte means by listening to one party. I guess we have also covered this. Ex parte means when only plaintiff is present or only defendant is present. Only one party is present in the court. The other party is not present in the court. And the court gives the judgment by listening to only one party because the other party is not present in the proceedings. That is known as ex parte order, ex parte judgment. Ex parte means proceeding in the absence of another party. Why? Because they are not present in the court. That is ex parte. Next is expressio unius est exclusio alterius. It means that if you expressly include something, it means you have excluded all other thing. Expressio means expressly. Unius means included something. Exclusio means excluded, which means automatically you have excluded other things. Example, if bus and truck is included. If you are saying only bus and truck, no other thing, only bus and truck, which means you are automatically excluding other thing. You are excluding car, you are excluding any other transportation. See, if in your CSAT exam, ICSI has told you you can give your exam only by laptop or computer, only by laptop or computer. So here only laptop and computer is included. It means all other things are excluded. It means phone is excluded, ipad is excluded, tablet is excluded. So if anything is expressly included, which means all other things are excluded. If ICSI has expressly told you only you can give your exam by laptop or computer, it automatically means you cannot give exam by any other thing, by ipad, notepad or itna. It is this is meant by expressio unius ex exclusio alters. If anything is expressly included, it means all other things are excluded, all other things are excluded. Yes, are we clear with this? Next is ex turpi causa non oritur action. We have already covered this in Indian Contract Act. It means no action arises from illegal action. If I myself has done illegal thing, I cannot take any legal action. I have paid 1 crore to murder someone, I cannot take legal action against the person. No action arises from the illegal action. We have already covered this in Indian Contract Act. Next is factum, means something which has already happened and which cannot be undone, which cannot be altered, which is beyond our control, which is beyond human control, which is already done, which cannot be undone or which cannot be altered, even though if it's not legally right. Example, child marriage. Child marriage is not right. Child marriage is not right. But if you have done it, you cannot undo it. They are already married. Unless and until proper divorce is done, you cannot undo it. So an act which is although not properly legal, but which is done and which cannot be done undone, which cannot be altered, which is beyond their control, that is known as factum. Factum. Next is fiat. Um, even crime. You cannot undo a crime now. If somebody is murdered, he is murdered, he is died. You cannot undo it. Yes. Okay, Pooja. Yes, next is factum probandum. Factum probandum. This, this sounds like that Harry Potter. Expecto patronum. Okay, so this legal terms. Read it like that only. You will enjoy it. Factors. Factum probandum. What do you mean by factum probandum? Factum probandum means fact in the issue which is to be proved. You have the thing which you have to prove. Let's say if I am saying I had a contract with Meghana that Meghana will sell her phone to me. Meghana will sell her phone to me. We had a contract, and later on, Meghana did not give his phone to me. Meghana breached the contract. So, if I file a case in the court against Meghana, I have to prove that thing. I have to prove what? I have to prove what? What I have to prove? I have to prove that Meghana has breached the contract. So the main thing which you have to prove in the court, that is known as factum probandum, the thing which you have to prove in the court, so for which you have filed a case, main thing which you have to prove in the court, that is known as factum probandum, thing which you have to prove, which is to be proved. To be proved. Example, if you are saying the other person has breached the contract, obviously you have to prove that in the court. So that is factum probandum, to prove the breach of contract. Next is factum probans. These two are related. Factum probandum means thing which you have to prove. Factum probans means fact with the help of which you prove a thing. Example, I have to prove that Meghana has breached a contract. For that, I need some evidence. I need some evidence to prove that Meghana has breached a contract. Those evidence which I use to prove a fact, that is known as factus probans. Example, what is factus probandum? if I have to prove that Meghna have breached a contract, then that particular thing that Meghna has breached a contract, that is factum probandum. Now, in order to prove that Meghna has breached a contract, first I have to prove that there is a contract between me and Meghna. And how can I prove that there is a contract between me and Meghna? I can prove that by giving a written contract. If I have a proper written contract, then I can show that contract. See court, this contract, see this court. In this court, it is properly written that Meghna has agreed to sell her phone to me. See this court. So this court is acting as an evidence. This court, contract see this contract. In this contract, it is specifically written that there is an agreement between me and Meghna to sell her phone. So here this contract is admissible as an evidence in the court of law, and court will consider this evidence. This evidence is known as factum probans. Factum probans means evidence which you use to prove factum probandum. Are you understanding? Factum probandum is what you have to prove, and the evidence which you use to prove factum probandum is factum probans. Factum probans are the evidence which you use to prove factum probandum. Are we clear with this? Yes. So what is factum probans? Relevant facts, evidence or facts by which factum probandum will be proved. That is factum probans. Next is ferae naturae. Ferae naturae means dangerous by nature. Example, wild animal. Example, lion. Lion is dangerous animal. Yes, don't try it. Okay, don't try it. Is it dangerous or not? Is it dangerous or not? It is dangerous. Don't try it. Okay. So ferae naturae. Naturae means nature. Naturae means nature. Ferae means dangerous. So something which is dangerous by nature. Example, wild animals. Wild animals are dangerous by nature. I too am very scared of wild animals. Example, lion, tiger. All these are wild animals. Okay, that is ferae naturae. Next is force majeure. This term you will encounter this term in your executive also, in your professional also, in all your corporate life. In all your corporate life, this is a very common term used in contracts. So understand this very properly. This you will use in your, you may encounter this term in your daily life, in your normal life, not daily life, but yeah, commercial life. Force majeure. Force majeure means something which is beyond one's control, which makes you safe. Example, act of God. Hurricane, is it under your control? Cyclone, is it under your control? No, that is act of God. So if you're not able to perform a contract because of act of God, then you will be saved if there is a force majeure clause in your contract. Example, I made a contract with let's say I purchased something from Amazon. Amazon promised to deliver my product on time. So there's a contract between me and Amazon. Now let's say something happened, COVID happened. Is COVID act of God? Yes. Let's say something happened, COVID happened. COVID is under our control? No, it is not under our control. It is not under the control of even Prime Minister Narendra Modi. So let's say something happened, COVID happened. Because of COVID, there was lockdown. There was a whole country was locked up. There was lockdown, and because of that, Amazon delivery was suspended for the time being. And let's say one day before the lockdown happened, I ordered my product, and from the next day, lockdown happened. So I ordered my product. There was a contract between me and Amazon, but Amazon is not able to fulfill the contract. Amazon is not able to deliver me my product because something which is beyond his control, something which is the act of God. Because of COVID, because of lockdown, he was not able to deliver my product. So don't you think he will be liable? Yes, madam, he will be liable to me. Can I file a suit against Amazon? Normally the answer is yes, I can file a suit against Amazon that I paid 60,000 for a laptop and Amazon is not delivering me laptop. But you know what? If in this particular contract, if in this contract, contract is a proper legal document, we have entered a force majeure clause. What does force majeure clause says? It protects you. In this you write that if we are not able to fulfill a contract because of act of God, In force majeure clause, we write this particular terms and condition, we write this clause in terms and conditions of contract, and mostly it is prudent to include a force majeure clause in all the contract. In this force majeure clause, we write in a contract that if I am not able to fulfill, if party is not able to fulfill their obligation under a contract due to act of god, then they will not be liable. They will not be liable. No liability will arise against them. You cannot sue them, you cannot take legal action against them. So it protects you, it protects you. This clause, force majeure clause, it protects you. Are you understanding? Force majeure, force majeure means something which is beyond one's control. Majeure, force majeure means something which is beyond one control, which is irresistible, you cannot resist it. COVID-19 example, act of god, earthquake, etc. So here usually we include this clause in our contract. Why? It protects a party from any liability for its failure to perform the contractual obligation. So if you have force majeure clause in the contract, then it will protect you from the liability in case you are not able to fulfill the contract because of act of god. Are we clear with this? Yes, this is force majeure. Next is generalia specialibus non-derogant. What do you mean by generalia specialibus non-derogant? It means general things do not derogate from special. This law also, you will it will help you in your executive also, in your professional also, in all your corporate law career, in all your corporate law career. What is the meaning of this? The meaning of this is general law does not prevail over special law, which means special law prevail over general law. Special law prevail over general law. I will give you one example. Remember, while teaching you section 1 of company law, I taught you one thing. If you remember, I doubt if you remember, but when I'll explain, you will remember it. Remember, when explaining section 1 of Companies Act, applicability of Companies Act, I taught you that is Companies Act applicable to insurance companies? Insurance companies? Yes. Companies Act is applicable to insurance companies? Yes. But for insurance company, there is a specific act made, Insurance Act. And IRDA Act, sorry, IDRA. IDRA or IRDA? Insurance Development and IDRA, I guess, Regulation, Insurance Development, Regulation and Development. It is either IRDA or IDRA. So this Insurance Act is specifically made for insurance company. So it is specific law. It is specific law. Specific means it is specially made for insurance companies. Insurance Act is specially made for insurance companies. Companies Act is the general law na. It is applicable to all type of company. It is applicable to insurance company also, banking company also, normal company also, NBFC also, dormant company also, nidhi company also, all type of companies. So it is general law. Now, is Companies Act applicable to insurance companies? Yes. Is Insurance Act applicable to insurance companies? Yes. The answer is yes. But for, if I talk about insurance companies, for insurance company, Insurance Act is specific law and Companies Act is general law. So if there is a fight between Companies Act and Insurance Act, insurance company will follow which act? Which act? Can you tell me? Yes. Insurance Act. Perfect. Insurance Act. Yes. So here, if there is a fight between general law and special law, you have to follow which law? Don't get confused. You have to follow special law. It's like your mother is asking you something else. Your mother is asking you to do something, and your father is asking you something else. Whom you should listen? You should listen to your mother or you should listen to your father. Your father is asking you to do something else. Your mother is asking you to do something else. Both are your parents. Whom you would listen? Whosoever is dominant in family, mom. Pooja is saying mom. So if mom is dominant in family, then you will listen to mom, and mostly mom is dominant. And yeah, so you will listen to mom, right? So here, if there is a fight between Companies Act, if there is a fight between general law and specific law, you have to listen to the specific law. So here, general law will prevail, specific law will prevail over general law, right? This is the meaning of this particular term, that general area, specialibus, non-derogate. General area means general law, specialibus means special law, non-derogate means does not prevail. So general law does not prevail over special law. So general law does not prevail over special law, which means special law prevail over general law. Are we clear with this? One more example I'll give you. Contract Act. Contract Act is a general law for all type of contract. It is a general law. It says that a contract can be oral or written, right? Now let's say you want to sell a land, you want to sell a property. For selling a property, you have to enter into proper contract. You are selling a property, you are selling a land, and if you are doing this now, there is a specific law made for this particular thing, which is known as TOPA. TOPA stands for Transfer of Property Act. Transfer of Property Act. If you want to purchase and sell any property, now immovable property, land, building, if you want to purchase and sell land, building, for this specific law is made, specific law only for this thing, TOPA. So TOPA says that sale of land contract should only be in writing, should only be in writing. Now you will follow, for if you are selling a land, will you listen to Contract Act or will you listen to TOPA Act? Obviously you will listen to TOPA Act. Can you say that no, in Contract Act it is said that contract can be oral or written, which means I can sell my land orally? No, TOPA is a specific law for selling land, so you have to listen to the specific law. Specific law prevail over general law. Are we clear with this? Yes. This thing, please understand this properly. This thing will help you in your whole corporate law career. Okay. Habeas corpus, I'm not going to explain this we have already studied this constitution chapter to have a body. We are done with 2 pages. What is the time? 8. Okay. In 1 hour, we did 2 pages. We are left with 3 pages. I guess in 1 hour, 1 hour or 1.5 hour, we will complete this chapter. Right? Because we are left with 3 pages. Yes. Okay. My bottle is empty now. Okay. Next. This two term we have already done in Indian Contract Act and Law of Torts. Ignoratia legis neminem exequatia. Ignorance of law excuses no one. Remember, we did this in mistake topic, mistake in Indian law. You cannot say that I don't know traffic rules. You cannot escape from penalty. If you have broken the traffic rules, then you have to pay the penalty. Ignorance of law excuses no one. You cannot take an excuse that I don't know the law. You should know Indian law, right? Remember, we did this in Indian Contract Act. After the injuria signed damnum, already done. Injury without damage, done in Law of Torts. Law of Torts. Next is interest republicae ut sit finis litium. What does this mean? You cannot file a litigation after years, which means state or public interest requires that there should be limit to a litigation, which means that there should be limitation of filing a case over a particular crime or a particular offense. You cannot take action for years and years, like for the state interest, in the public interest, or in the government interest. In the government interest, there should be a limit to litigation, where a litigation to stop. Let's say some wrong is done to Mr. X. Now Mr. X has taken no action. Son of Mr. X has taken no action. Grandson of Mr. X has taken no action. Now grandson of Mr. X will take up that file and will come to the court and say, I want to take action against the wrong done to my great grandfather. Can he do so? court will not entertain this case. You cannot start any litigation after years. After years, action should be taken within a reasonable time, so that even a court do not get unnecessarily irritated because of anything which is not very important, right? So in the public interest, in the court's interest, it is important to put a limit on the litigation. You cannot come after 100 years and take an action for anything which is done 100 years back. There should be a limit, that okay, this is the limit, and after this you cannot take action. And on the basis of this law only, we have one act. Do you know the name of that act? On the basis of this law only, we have an act, and the name of that act is Limitation Act. Remember, we have studied Limitation Act. In that Limitation Act, a time limit is given, that if some wrong is given to you, done to you, you can take action only within this much time. You can take action only for next 3 years. If till next 3 year you don't take action, then after that you lose your right to take action. Why this act is based on the concept of interest republique uh, at sin finis litium, which means there is an end to litigation. You cannot take any litigation, you cannot file a case after some time. You cannot file a case, you lose that right. In the public interest, there is an end to litigation, there is end to your legal right till when you can take action. That is republique at sit finis litium. Yes, can we move forward? Yes. Ipso facto, I must say that you must have heard this term a lot of times. Have you heard this word ipso facto? Ipso facto means by the very nature itself. You haven't heard it? Ipso facto means by the very nature of the case. It means that something which is by its very nature void, which is by its very nature proved, you don't need to prove it, or you don't need to give evidence for it. It is by its very nature proved by ipso facto. Example, in Hindu marriage, a man can marry only one woman. If that woman is alive, while your wife is alive, you cannot do another marriage in Hindu law. So if your wife is alive, can you do another marriage? No. In case you do another marriage, that later marriage is ipso facto void. Ipso facto means by itself void. No need to prove anything. No need to give any supportive evidence or do anything. That marriage is done. That act by itself is enough. That act by itself is enough. That later marriage is ipso facto void means by itself void. Just because that thing has happened, it is proved by itself. It is by very nature of the case. So it is by very nature that, yeah, later marriage, second marriage, it is ipso facto void. Ipso facto means by the very nature of that act itself, it is void. No need to prove anything. Yes, are we clear with this? Yes, that is ipso facto. Next is in promptu, means in readiness. Readiness means something which happens very suddenly without preparation. Okay, we are marrying. Suddenly, like yesterday only, I saw one meme that two people, they fall in love in the exam hall, and they got married in the exam hall itself. You don't do that. Please, you don't do that. You focus on your examination. So that is sudden without any preparation. So promptly means suddenly. Impromptu means in readiness, means suddenly, which is anything which is done without any preparation. That is impromptu. In posse means in the state of possibility. If it is possible, it is in posse. In posse means it is possible. Is it possible to score AIR? Yes, AIR 1 is in posse. Means it is possible. It is possible to do. It is possible to achieve. It is possible to do. It is in posse. Posse means possibility. Posse means possibility. In posse means in the state of possibility. Having potential to exist. या फिर इग्नोर दिस, इट बहुत ज्यादा हो जाएगा. Just do this. Possible or potential. Next is in limine. In limine means initial stage. Initial stage means from the very beginning, at the very beginning. Example, if you filed an application to the court and court did not even admit that case, from the very initial stage, court dismissed your case. Court did not even started hearing at the very beginning, from the very beginning, at the initial stage only, when you filed an application to the court, at the initial stage only, at the first stage, like the proceeding did not even started on the first application only, at the initial stage only you got rejected, at the initial stage only you got rejected. So if court dismiss a case at the first stage only, then it will be said that court dismissed the case in limine. In limine means at the initial stage. In limine, initial stage, at the initial stage. Are we clear with this? Yes, in limine means at the initial stage. In lieu of, already done. Instead of, you cannot give cash, you cannot give you cannot give dividend in lieu of bonus share. What is bonus share? You might not have studied what is bonus share. When you give free shares, that is bonus shares. When you give free shares, that is bonus for free, bonus. When you give free shares, that is bonus share. For now, understand this much only. In executive, you will study bonus share in very much detail. So instead of, you cannot give dividend in lieu of bonus share, which means you cannot give dividend instead of bonus share. In lieu of, instead of. Inter alia means among other things. When you are saying a lot of things and you want to make one point as a focus, you say inter alia. Inter alia means among other things. Among other things means for more focus, or for pointing out one thing over others, when there are lot of things or list of things. Like when there are list of things and you want to bring a focus on a particular thing, you say inter alia. Like I went to the supermarket to purchase grocery. Inter alia, uh, milk means groceries also, along with that milk also. So you want to focus on some specific thing among a list of things, then you say inter alia. Inter alia means you want to focus on a particular thing among all other things, among whole list, among all other things, that is, then you use inter alia. Inter se, among themselves. Inter se, among themselves, we have already covered this earlier. In specie means in kind, in a similar manner. Specie means of that kind, of a similar manner. Like when you are discussing a case and you have already dealt with a similar case earlier, you will say it is in specie, means it is similar case, it is of similar kind, it is of similar kind. In specie means in similar kind or in similar manner. Inter vivos. Inter means between, intra means within, you know na, inter means between. Inter vivos, vivos means living beings, living person. So something which is done between living person. Like if I am transferring my phone to Vega, so here it is inter vivos, because this transaction is between two living person. I am also living person, Vega is also living person. So when a transaction is done between two living person, it is known as inter vivos. Inter vivos means between living person. Example, transfer of property between survivor. Like let's say father died and property of father got transmitted to son, that is not inter vivos. Why? Because after father died, all the property of father transferred to son. But here the father's property is transferring, father is not alive, father is died, father is dead. So here that is not inter vivos. Inter vivos means transaction between two living person. Next is intravirus. I guess I have taught you intravirus. Intravirus means within the power, ultravirus means outside the power. Let's say my mother gave me a permission, I can stay out of my home till 10 p.m. So I have power to stay out of my home till 10 p.m. I do not have power to stay out of my home after 10 p.m. So if I stay out of my home before 10 p.m. I come back to home at 10 p.m. Then I did something which is within my powers, that is intravirus. Ultravirus means I stayed at home beyond the 10 p.m. Then I do not have power to stay at home beyond 10 p.m. Still I stayed at home after stayed outside home after 10 p.m. That is ultravirus. Ultravirus means beyond the power. See, ultravirus will also come somewhere. Ultravirus. Ultravirus in the last page, ultravirus means beyond the power. So let's say if in our company, where there is a company named Yashas Academy, in our object clause, array, what is object clause of memorandum? What is memorandum of association? Biodata. Remember kya? Yes, MOA. In MOA there is 6 clauses. Among those 6 clauses, one clause is your memorandum of association. Array yaar. Among those 6 clauses, one clause is your object clause, and in that object clause we write our powers. Like Yashas Academy can provide education, so in our memorandum we are permitted to provide education. So if we provide education, that is intravirus, that is within our power. If we start doing selling clothes, if we start selling clothes, is it permitted? Is it within the powers of the company? No, it is not permitted in memorandum. So if we start selling clothes, that will be known as ultravirus, means beyond the power of company. Intravirus means within the power, ultravirus means outside the power. Are we clear with this? Yes. In personam means when you try to take any action against a particular person. Let's say Mr. A stole my phone. Mr. A stole my phone. So I will file a case against Mr. A. When I want to take any action against a particular person, and when I want to take a relief from a particular person, I want to take action against a particular person, that is known as in personam. Personam means against a particular person. Personam means person. When I want to take a relief, when I am taking any action against a particular person, when I am filing a case against a particular person to take relief against that person, that is known as in personam. Next is indicia. Indicia means indications, direct indication, distinctive sign, uh, the your fingerprint are matching with the fingerprint on the gun. It is an indicative sign that you have done the murder. It is an indicative sign that your fingerprints are matching with the fingerprints of the gun, fingerprints on the gun. Then it is an indicia that you have done the murder. Indicia means indications or distinctive sign. It is directly indicating that you have done something. Okay, that is symbol, token, mark, indications or distinctive sign. Innuendo means elusive mark, means something which is suggesting you have done it indirectly, not directly. That is innuendo means elusive mark. Elusive means a remark that suggests something but not refer to it directly. Like if I am saying ki maybe um someone who is the prime minister of country has done the murder. Here now I am indirectly making some allegation. I am indirectly trying to prove something. That is, I am indirectly trying to suggesting something. That is innuendo. Innuendo means elusive remark. When you're trying to suggest something indirectly, not directly. A remark that suggests something but not refer to it directly. Matlab, a thing which is proving that you have done a crime but not directly proving it. It is suggesting that you have done a crime, but it is not a conclusive proof. It is not directly proving that you have done a crime. It is just supporting. It is just suggesting something but not a confirmation. It is not a confirmation. It is just suggesting something, a remark that is suggesting something but does not prove it directly. That is innuendo. Are we clear with this? Yes, that is innuendo. Just in personam, just in rem, we have already done in Indian Contract Act. Just in personam means right against a particular person. If there is a contract between me and Vijay Devakonda to marry each other, then I have this right only against Vijay Devakonda, that you have to marry me because you did this contract with me. I cannot exercise this right against any other person. I have this right only against Vijay Deverakonda. In case of contracts, you have right in personam, means right only against a particular person. Just in rem means right against the whole world. If this phone is mine, I have right on this phone against the whole world. Against the whole world, nobody can take this phone from me without my permission. So if something is mine, something is mine, I have right on this property against the whole world. That is just in rem, right against the whole world. Next is just non scriptum. Scriptum, it is scripted. We say na scripted means it is already written somewhere, it is already decided. A non scriptum means unscripted. Unscripted means unwritten law or customary law. A law which is based on customs, but it is not written somewhere. Example, law of torts. Law of torts is based on judgments of court, but it is not a proper act passed by parliament. So a law which is not a proper written law, rather it is customary, based on customs and traditions of people, that is just non-scriptum. Just scriptum means written law. Just scriptum. Scriptum, scripted, written law. Non-scriptum, non-written law. Unwritten law, very easy. Just written, scriptum, written law. Just non-scriptum, unwritten law or customary law. Are we clear with this? Yes. Yes. Few more. Lex Marcoteria. नहीं Marketoria. Lex Marcoteria means some legal customs which you derive from international law. See, in India, we make a lot of law based on international law. So if we see the international trade, and on the basis of that international trade, we make some legal customs, industry practice, or some general principle for India. That is known as lex marketoria, means any legal merchant or legal body or legal principles or legal law or legal rules or legal custom which we have made on the basis of international law, on the basis of international trade, that is known as lex marketoria. Means body of legal principle, some legal customs, some practice, some principles which are already in existence in the international trade, which we have derived from the international trade, which are already in existence in the international trade. Now we have started using those customs, those practice, those principles. That is known as lex marketoria. It is also known as law merchant. It is also known as law merchant. Lex marketoria is also known as law merchant, means legal customs, legal principles, legal practice which we follow based on the international trade, based on the international trade. That is lex marketoria, means law merchant. Lex fori means law of the forum of the court, means law of the land, which means that if, let's say, any case is filed in India, even if someone from America has come to India and they have filed a case in India, will we consider the law of America or will we consider the law of India? Obviously, we will consider law of India in order to solve that case, in order to accept evidence. That is known as law of forum of court, means law of the land. Law of the land. If any case is filed in India, it will be dealt according to Indian law, even though the case is even though the case is filed by some foreign person. And there are some state laws. Remember, even state government makes some laws for the state. So in India, law is made at both level, at central level also, at state level also. So if I talk about some laws, they differ from state to state. Example, stamp duty. Stamp act is different of different state. For Maharashtra, there is different stamp act. For UP, there is different stamp act. For Karnataka, there is different stamp act. Similarly, if I talk about evidence act, it is different for different state. For UP, it is different. For Karnataka, is different. For West Bengal, it is different. So if any case is filed in a West Bengal court, then West Bengal will deal with that case according to the law of West Bengal and not according to the law of UP or not according to the law of Karnataka. And if any case is filed in UP court, then UP court will deal with that case according to the UP law, not according to the West Bengal law or the Karnataka law or Chhattisgarh law or Maharashtra law. That is known as law of the forum of court. Where the forum of the court is, where the court is, they will follow the law of that forum only. They will follow the law of that land only or that state only. That is known as law of the forum of court, law of the land or state. Example, UP court may say that it will refer to Evidence Act of UP. It will not refer to Evidence Act of any other state. Are we clear with this? This is known as Lex 4E. Lex means law. Lexus Nexus. Lex means law. Please understand and remember this forever. Lex means law. See here, Lex Marketoria. Lex means law merchant. Marketoria means merchant. Lex means law. Lex always means law. Lex 4E means law forum of age court. List means suit. When you file a case now, that is known as list. List means suit of action. List pendens means a list of pending suit. If a suit is pending, that is list pendens. Pendens means pending. List means case. List pendens means pending case. Pending case. Very easy. Locus standi. Locus standi means right of the party to stand or appear before the court. That is known as locus standing, place of standing. If somebody has filed any case against me, if somebody has made any accusation against me, I have right to appear before the court, to go to the court hearings, and right to speak. Right to speak. That right to appear, I have some locus. Locus means legal. Standing means standing. I have legal standing, means I have legal right to claim this. I have legal right to speak. I have legal right to appear before court. That is known as locus standi, means I have legal right to take action. I have legal right to appear before court and speak before court. That is known as locus standi. Locus standi means right of a party to appear and be heard in a court of law. In a court of law. Since this all are legal terms, that is why they are related to courts, proceedings, civil case, criminal case, corporate case. Why? Because these are legal terms. These are legal terms. That is why this is related to courts, hearings, and all only. Locus standi means your right to appear and be heard in a court of law. Now, these three are already done. Malafide means bad faith. We have done this in Indian Contract Act and Law of Torts. Mandamus, it is a type of writ petition. Writ petition issued by higher court to lower court. Mandamus, right, means to command. Here, the higher court is commanding the lower court to not decide a case. That is mandamus, right? We have studied this in Constitution of India. No, mandamus was different, kya? Just a second. Yes, yes, yes. Sorry, mandamus was means we command. It means where the court is commanding someone to do their public duty who fails to do their public duty. That is mandamus. Yes, this was mandamus. We have already covered this in where we have already covered this in Indian Constitution. Mens rea, already covered in Indian Contract Act. Mens rea means guilty mind. Ria, not Ria Chakravarti. Mens rea means guilty mind. These three are already covered. Yes, this is covered in Constitution of India. Malafide is covered in Contract Act, and mens rea is covered in Law of Torts. With this, we are done with 3 pages. We are left with 2 more pages. Yes, break of 5 minutes. Break of 5 minutes. I'll just get my water. Break of 5 minutes. Till then, you can revise. You can revise this. Okay. And we will do the remaining 10 minutes. Don't leave the lecture. Don't leave the meeting. I'll just come in 5 minutes. Okay. We'll resume this. Okay. So, ma'am, 5 pages legal maximus given in your book. We are done with 3 pages. 1, 2, and 3. We are done with 3 pages. Now, only 2 pages are left. So, we will do that now. Easy, easy, not very difficult. Not very difficult. Only we are almost there. We are almost there. Keep patience. Okay. Easy, easy legal maxims are left. Next, I'll try to take it a bit fast, in a faster manner. Menacute nature. Remember, we did fiste nature, with nature, sum to nature, faire nature. Fere nature means dangerous things, wild animals. Example, lion. Remember, fere nature. Similarly, menestrute nature means harmless by nature. Pet dog. Example, cow. Cow is menestre nature. It is not wild animal. It is pet animal. It is pet dog. It is pet dog. Pet dog. Arey yaar. Pet animal. Pet animal. Example. Example, cow, dog. So that is your harmless by nature, which is by nature harmless. It does not harm you. Example, rat, cat, all these are harmless by nature, so they are menestue naturae. Fere naturae means harmless, a wild animal. Menestue naturae means pet animal who are harmless by nature. Next is mean profit. It is basically the word is MESNE, but here S is silent, so it is pronounced at mean profit or many profit. Mean, man or mean profit. The S is silent here. What do you mean by men profit, mean profit? The rent or profit which a trespasser has received or made during the occupation of premises. If there is a trespasser, any trespasser has come to your house, entered your house without permission. He took laptop and went away, and that profit which he made by trespassing is known as mean profit. It is illegal profit. If he trespassed your property and he stole something, he took something from your property, or he made some profit from that property, that is known as mean profit. Mean property means the rent or profit which a trespasser has received by the occupation of that premises. Let's say I have one land in my gaon, in my village. I don't visit that village. Somebody trespassed into that land and gave it on rent and earning rent income. Is that land his? No, that land is mine. But he trespassed my land and he earned rent income from that property. That profit will be known as mean profit. Misnomer means taking someone's name wrongly. Taking someone's name wrongly, right? That is misnomer. Misnomer, calling someone by wrong name, or calling something by wrong name. That is misnomer. Mutatis mutandis means we have already done with the necessary changes, like the law will be applicable to this. Mutatis mutandis means as it is, only with the necessary changes. It will apply same to shame, only if necessary changes is there, we will make necessary changes, otherwise that law will apply mutatis mutandis. Example, uh, example, in a partnership firm, the law which is applicable to retired partner is also applicable to expelled partner. So I will say that the law of retiring partner will apply to expelled partner. Mutatis mutandis means this law will apply to this situation also, only if necessary changes is required, we will make that necessary changes, otherwise this law will be applicable to this situation also. That is mutatis mutandis, means as it is, only with the necessary changes required. Next is nostita or sauces. Sauces, nostita or sauces. What do you mean by nostita or sauces? Means to know something from the company. Example, sometimes we do not know a meaning of the word, but by reading a sentence, by reading the associated words, we got to know the meaning of that word. That is known as nosita or sauces. Means you don't know about something, but you know a meaning of a particular word by the associated words, by the sentence. That is known as nosita or sauces. Nosita or sauces means a word to know by its associated, one by his companies, to know from the association. Example, meaning of unclear words are understood by the associated words in a sentence. If there is a sentence, a word is used, I'm not sure about the meaning of that word, a meaning of the word is unclear, then we try to interpret the meaning in context of a sentence. That is known as nosita or sauces. When you try to understand the meaning of a word, when you try to understand the meaning of an unclear word by the associated word, by the other words used in a sentence, by the context of a sentence, that is known as nosita or sauces. Yes. Next is obiter dictum. Obiter dictum means opinion of the judge which is not binding. Remember, I taught you dictum, dictum, dictum we studied here. Remember dictum? Dictum, I taught you dictum. Dictum means opinions given by court which is not a decision. That is dictum. Opinions, dictum is also same. Opinions given by court or judge, which is not a main decision, which is just opinion or court or a suggestion of the court, it is not compulsory to comply with that. That is known as dictum. Dictum, right? And also, where was we was obiter dictum. Obiter dictum also means same. Obiter dictum means suggestion given by the court, which is not binding, which is not binding. Opinions given by the court, which is not the main judgment, which is not binding, which is just suggestions or opinion given by the judge. So any incidental opinion given by the judge, which is not binding, which is not compulsory to comply, that is known as obiter dictum. Next is onus probandi. Onus probandi means burden of proof. Onus will be on you. The burden will be on you. Onus means burden. Probandi means to prove. So onus probandi means burden of proof. So let's say that if I am saying that you have trespassed my house, if I am making a statement, I have to prove that statement, which means the onus probandi is on me. The burden of proof is on me. So if a person is asserting, making any statement, then the burden of proof is on him. Then he has to prove that in the court. That is, the burden of proof is on me. The onus probandi is on me. Onus probandi means burden of proof. Pari passu. I guess you already know the meaning of pari passu. Have you heard this word before, pari passu? Pari passu means on equal footing. Equal footing. Like all the CSEET students are pari passu, means you all are equal footing for me. Nobody is superior, nobody is junior. You all are in equal footing. You all are having equal rights. You all are having equal standing. Equal footing. That is pari passu. Per se. Per se means by action itself, like actionable per se. Remember, I taught you actionable per se. Action itself is enough, no proof is required. Example, trespass. Trespass is done itself is enough. You don't need to prove anything. You don't need to prove that actual damage is there. Actual proving actual damage is not required. Per se means by itself, no other thing is required. Example, actionable per se, which we have already done. Next is persona non grata, means person not wanted, unwanted person. Unwanted person. Like if if BJP is having a meeting, Rahul Gandhi comes to that meeting, he is not wanted. Persona not wanted means persona non grata means person not wanted. Grata means wanted, persona means person. Unacceptable person. Sometimes our government don't accept a person in India. Like you cannot settle down in a country without having a permanent visa. A foreigner cannot settle down in a country without having permanent visa. That person is unacceptable. If you go to some other country without passport, without visa, will that be acceptable? No, you will be unacceptable person. Like Bajrangi Bhaijaan, that Salman Khan in Bajrangi Bhaijaan movie, he went to Pakistan without passport, without visa, so he was unacceptable person in Pakistan. So he will be known as persona non grata. Pakistan government will not accept him. Pakistan government will not accept him. Example, Indian enemy. If we are having a fight with China, if any Chinese people will come to India, our Indian government will immediately ask him to go away, to leave India. Indian government will not accept that person. That person will be known as person not wanted, persona not gratia. Are we clear with this? Persona not gratia means person not wanted. See, some words are itself clear by the term itself. Persona non grata, person not wanted. Itself clear. So even if this will come in exam now, that what is the meaning of persona not grata? Four options. By itself taken alone, person not granted, through want of care, at first sight. By reading the option itself, you will understand that persona non grata means person not wanted. So don't take too much headache of this chapter. You will have option, you will have MCQ, you don't have to write on your own. So even if you read it, most probably 90%, 80-90% of the time you would be able to tick the right answer. By just reading the option, you will get this is the answer. So don't take too much headache that how will I remember all this legal maxim. Just read it with a chill mind in your free time, after doing other topics, other chapters, right? Don't take too much headache, don't start mugging up every word. Just go through it 2 to 3 times whenever you are having a free time. Whenever you are tired of studying other subject, just take legal maxim and go through 1 or 2 pages. every time. Okay, that's how you can prepare. Don't take too much headache of legal maxim. You will be having options. By reading options also you can understand. So just try to link few words. Persona means person. So by this also you will understand that that option is correct in which person is there. Persona not granted. Work smartly here in legal maxims. Okay, persona not granta means person not wanted. Per incurium. Per incurium means lack of care or lack of diligence. Sometimes court give a decision without properly referring to a law, in ignorance of law. Sometimes court give wrong judgment in ignorance of law or in ignorance of previous judgment of the court. Previous judgment of higher court is known as precedents. So if a lower court gives any judgment without considering the law, without care, like carelessly. Per incurium means carelessly. If court give a decision in ignorance of a law, without care, lack of care, inadvertence means negligence, without care, that is known as per incurium. Prima facie, we have already done this at the first instance. Prima facie at the first instance, on the first side. If share certificate your name is written, then you are the prima facie owner of that share. Means at the first sight on the face of it. Next is profita pendia. Profita pendia means the profit which you derive from the soil or land of another person, that is known as profit or pendia. Very basic example I'll give you. Somebody has given me right to access a garden, so if I pluck one flower from the garden, I have taken a benefit from the soil, from the land of another person. That is profit appender. This is related to land. I have taken a benefit or a right from the soil or land of another person. That is profit appender, means right of a man in respect of treatment. Here, when you take a right from another person's property, when you take some profit or you get some rights in another person's property, that is known as profit appender. Pro bono publico means for the public good. See, pro bono to means for good. Pro bono means good. Publico means name itself suggesting public, so you don't have to put efforts in remembering this. Pro bono publico, for public good. By seeing option you will understand that yeah, this is the right answer. You will be having four options, don't worry. Pro bono publico, for the public good. Pro forma, format, we already know. Pro forma of letter, pro forma of email. Pro forma means format, we already know, in a particular form. Pro rata means in appropriation. Proportionate. Pro rata means proportionate, right? Posteriori, already done. It has a similar meaning to a priori. A priori, the first term which we did, a priori. Posteriori has the same meaning of a priori. Posteriori has the same meaning of a priori. A priori was the first word which we did. A priori means from the antecedent to the consequent. When you reach to a conclusion based on your earlier experience, when you decide something on the base of earlier experience, that is a priori. Remember, a priori, prior experience, and this is same with posteriori. This is same as posteriori. Yeah. So posteriori means having the same meaning like a priori, from the consequence to the antecedent, right? Just a second. I'm really sorry, I did one mistake. It is opposite of a priori. A priori is from the antecedent to consequence. It is from consequent to antecedent. So I'm really sorry. I correct myself. I take back my words. I here put posteriori is just opposite of a priori. A priori means when you derive something from earlier incident without logical consequence, without logical thinking, without logical analysis, you just assume something from the previous experience. That is a priori. Posteriori means from the consequence to antecedent. Here, first you do logical analysis and then you derive at the consequence. You don't assume anything from earlier experience. You don't assume anything from earlier experience, rather you bring conclusion from the logical analysis, from logical examination, by giving logical reasoning, by doing logical analysis, you reach to a conclusion, and that become your basis, so from consequence to antecedent, there you don't use to do logical analysis, you just assume on the basis of previous experience. Here you don't assume on the basis of previous experience, you do logical analysis and then you derive to a conclusion, that is posteriori. Next is pune mortgage, means second mortgage means, let's say I have a property, I have a land of 5 crores, I have a land of 5 crore, I took one loan from SBI of 1 crore, and I mortgage this land to SBI, but that this land value is for 5 crore. Now let's say again I took 2 crore loan from PNB, Punjab National Bank, and I mortgage the same land to PNB. So I am creating second mortgage in the same property. I am creating the second mortgage in the same property. It is known as pune mortgage or second mortgage or subsequent mortgage on the same property. Are we clear with this? Pune mortgage? Yes. Yes. Next is pari causa. Pari passu, equal footing. Pari causa is also similar. Similar circumstances. Causa means situation, circumstances. Pari causa means in a case where all the parties shall stand equal in right according to law. This has similar meaning to pari passu, means similar circumstances, similar situations, everybody having equal right, everybody in the same situation, similar circumstances with equal right, same situation also in the same right. So it is a situation where all the parties are having equal right and they are in the equal situation, then we say it is pari causa. Pari materia. Pari materia means of the same subject matter, used in interpreting laws relating to same subject matter. Now let's say if two law are related to same subject matter, or if you are deciding two cases on the same subject matter, then they are related to each other. So let's say you gave one judgment on let's say um, murder, and that similar situation, that similar murder happened again. So you will use that earlier judgment here also, in this case also. So that is, two cases are having same subject matter, they are relating to same subject matter, that is pari materia, means relating to same person, same thing, that is relating to same subject matter, that is pari materia. Now this two term we have already done in torts and constitution. Q facet per alium facet per se means he who act through other is acting himself, which means if I am acting through other, it will be deemed that I am acting myself. If I am getting my work done by my agent, it will be deemed that I have done that agent, I have done that work, and I will be liable for the act of my agent. That is, he who acted through other is acted himself. If I have asked my driver to drive a car, he has made an accident, it will be deemed that I was driving a car and I did accident. So he who act through himself is acting himself. This we did in law of torts. Quo warranto, we have already done. Quo warranto, it is a writ petition, it is a writ order which can be given by Supreme Court and High Court. We have already done this in Constitution of India. So quo warranto means what is your authority. If any public body is holding any, if any person is holding any public office and he is not eligible to hold that public office, then court asks you what is your authority. That is quo warranto. We have already done this in Constitution of India. Next is QR time it. What do you mean by QR time it? Protective justice to fear. Sometimes you give some order so that people do not do that wrong again. Sometimes it's necessary to give a judgment against a person so that that wrong will not be committed again. That is cure time it, to create a fear. Protective justice for fear. You are giving a justice to create a fear among people that they do not do this wrong again. It is an action brought to prevent a wrong that is apprehended. If you're thinking that people usually do this offense, so you give judgment against that thing to create a fear in people's mind so that they do not do that offense again. That is q time it. Q time it means protective justice for fear. It is action brought to prevent a wrong that is apprehended. Quid pro quo, we have already done in Indian Contract Act. It is it is something for something, something in return, consideration, quid pro quo. If I'm selling my phone to Meghna for 2000 rupees, then for me consideration is 2000 rupees. For Meghna, consideration is phone. It is something in return. Quid pro quo, we have already done this in Indian Contract Act. Quid pro quo means something in return. Ratio dicendi. Ratio dicendi means reason underline a decision. If I am giving a decision, court, I am not court, court is giving a decision, then the reason, the principal reason for giving that decision is known as ratio decidendi. Decidendi, ratio decidendi. It is a proper legal term used by courts. I guess my pencil charge has. Oh my god. Anyways, I have written everything, so I don't have to write anything. Yeah, ratio dicendi. Ratio dicendi means when a court is giving a decision, the major reason for forming an opinion, for forming a decision, that is known as ratio dicendi. Sorry. Next is res judicata. Res judicata means case which has already been decided, which court will not entertain again. If court has already given a decision on a matter, that same court will not entertain that case again. Court which has already been a case which has already been decided by a court, which it will not, it will not entertain again, that is known as res judicata. Res means case, judicata means which has already been decided. Res judicata means case which has already been decided, and court has given a decision, and that particular court will not entertain that case again, that is res judicata. Next is res ISPA locutor means accident whose occurrence is enough to prove negligence. Thing speaks of itself. Like example, if I was doing anything, if let's say I was driving a car, I was driving a car and I hit someone, that accident itself, that incident, that act itself is enough to prove my negligence, that I was negligent, I was carelessly driving, I was carelessly driving fast, so that is why I hit a particular person, so I will be liable. There is no need to prove that whether there was my negligence or not. If I hit someone by my car, just by that act itself it is proved that there was negligence. There is no need to prove that there was negligence or there was no negligence. No, just because you hit someone, we will deem that there is negligence and you will be liable. Just because that incident happened, that act happened, it will be proved that yeah, there is negligence and you will be liable, no matter what you say. That is res ipsa locutor means things speaks of itself. If you did accident, you hit someone by your car, it is speaking by itself that you were carelessly driving. No need to prove anything, and you will be held liable. That is res ipsa locutor. Respondeat superior, we have already studied this in law of torts. Let the principal be liable. If principal is getting any work done by agent, principal is superior, so superior will be responsible. Respondeat superior means responsibility will be on superior, responsibility will be on principal, which means let the principal be liable. If I asked my Ramu agent to purchase biscuit for me, so I will be liable to pay for that biscuit. Let the principal be liable. We have already done this in law of torts. Res subjudice means case which is still pending, it is still going on. See, res judicata means case which has already been decided. Res subjudice means it is under consideration, it is under proceeding, it is still deciding, it is not yet decided, it is yet to be decided, it is still going on. That is res subjudice, matter under consideration. Are we clear with this? Res subjudice. Yes, with this we are done with 4 pages of your legal maxim. Thank you for your patience, and we are left with the last page. Yes, yes. 1 minute break. 1 minute break. Yes. Okay. Now we are on the verge to complete our legal aptitude chapter. We are on the verge to complete our legal aptitude chapter. Last page of legal maxim. Last page. Yes. Okay. Yeah, why it is not charging? Okay. Res geste. Res geste means facts relevant to a case, facts which are admissible as an evidence. See, sometimes you don't quote admit the main facts as an evidence, but along with the main facts, court consider other facts also, other related facts also as an evidence. Like, okay, if murder was done, who was in the site of murder, okay, you was doing what, he was doing what. Like, court don't only consider the main fact, rather court consider related connected facts also to come to a conclusion. And when court consider the other related facts and admit that as a valid evidence, that is known as res geste. Res geste means facts relevant to a case which is admissible and as an evidence, connected with the main facts but not the main fact itself. It is connected facts but not the main fact itself. Next is rule nisi. Rule nisi means um, nisi means unless, rule means law. See, rule nisi means court says, showcase as to why you should not we should not allow the case, otherwise we will allow the case. Sometimes when a case is filed against you, court issues you show cause notice. Have you ever heard about show cause notice? Court issues you show cause notice, that if someone's want to file a case against you, then court issues you show cause notice. In that show cause notice, court asks you to give a reply, that please reply why we should not accept this case. If you won't reply, then we will accept this case. We will accept this case. So that is rule nisi means a rule which is indeed, which is imperative, which is final, unless you show otherwise, unless you prove otherwise. So sometimes court says that we will assume this. If you don't prove anything against this, then we will take this action, we will assume this. And if you don't want us to assume this, then you have to prove it, you have to show it. So that is rule nisi, rule which is applicable unless otherwise proved, unless anything shown against it. Rule nisi, rule which is imperative unless anything proved against it, a rule which will become imperative and final unless cause to be shown against it. Sometimes court says that you show cause why we should not accept a case. If you don't, then we will assume this case is valid and we will accept this case. So that is rule nisi. Next is scare facius. Scare facius means let them know. Your cause to know. Let them know that, okay. Scare facius means if you file a case against someone, let them know that you have filed a case. Let them inform. Scare facius means let them know. Status quo means existing state of something. What is your existing state? Okay, I am insolvent. That is your existing state. Status quo, existing state of a particular thing on a particular date. Existing state of a particular thing on a particular date. Next is sentient voluntary non-fit injuria means injury not done to know who knows and wills it. If I say someone come, okay, slap me. If someone is saying I'll slap you, I said okay, slap me. Gandhi ji says that when someone want to slap you, slaps you in one cheek, show them another cheek to slap. So if you are slapping me and I am accepting it, I showed my cheek, okay, slapped it, slap me. So here I am accepting it. Now later on, can I take action? Can I file a case that you slapped me, you did a tort against me? No. If you yourself are willing to do something, you are giving permission, later on you lose your right to take action. Later on you cannot take action. You yourself permitted to slap him to slap you, now you cannot take action, right? Example, if a person give consent to cause harm to himself, he cannot take remedy, right? Are we clear with this? Scientist voluntary not fit injuria. Next is space succession. Space succession means something which you are not sure which you will succeed. Example, let's say Amitabh Bachchan has not yet made his will. So usually Abhishek Bachchan will think that Amitabh Bachchan will give all his property to his son in his will, right? Succession means which you get something after your successor, after your father dies, after your successor, after your predecessor dies, which you get as a succession. That is your succession. Spec means chance. Spec means which is not yet sure. He might get that, he might not get that. It might happen, it might not happen. That is spec. Spec means There is a chance of happening it, but it's not sure whether it will happen or not. So if we are not sure whether Amitabh Bachchan will give his property to his son or not, but he has chance, he has hope that he will get his father's property as a succession. That is best succession. It might be possible that Amitabh Bachchan will donate all his property to trust, to charity after his death, like Ratan Tata, like many other people. So it might be possible that you can, in your will, you can write that after my death, all my property should be given to charity. In that, will Abhishek Bachchan get any right over the property of Amitabh Bachchan? No. So that is space succession means Abhishek Bachchan is not yet sure whether he will get succession over his father's property or not. There is chance of getting, there is chance of not getting. That is space succession, mutual chance. Are we clear with this? Yes. Next is Sapra. Sapra means uh, if a court is giving a judgment, judge is giving a judgment. If I have already explained a word before, we will not explain that word again. Simply, we will give reference to above, that we have referred this word above. So, we will not explain, discuss that word again. That is known as sapra. Example, like I have discussed this word suo moto earlier. So, I will not discuss this again now. So, that is sapra. Sapra means a word came. A word came, and the meaning of that word is already discussed in the same document. In the same document, the meaning of this word is discussed earlier. So simply I will write in bracket, I will write sapra. Sapra means this word is already been discussed earlier in the same document. Yes, are we clear with this? Yes, that is sapra. Sapra means a word which is already been discussed earlier in the same legal document. Next is suppressio veri. Suppressio veri means misrepresentation of truth by omission or suppression of fact. Suppressio means suppression. Suppression means you are suppressing some information, you are concealing some information. I am misrepresenting any information, or I am not giving any information with the wrong intention. That is suppressio veri. Suppressing any information or not telling any information, omitting any facts, important facts, or misrepresenting the truth. You are doing wrong with someone, you are deceiving someone by misrepresenting the truth, by not telling the truth, by suppressing the truth. That is suppressio veri. Sui juris, we say now, sui juris means it is your legal right. A person who is sui juris can enter into contract. Means a person who is competent to contract can enter into contract. Sui juris means it's your right to enter into contract. Major is sui juris to contract. Means a major has a right to contract. Sui juris means you have legal right. You have right. It is your right. Sui juris. It is a legal term. It will come again and again. This is a very common term. You will encounter this term in all your CS life. Next is simpliciter means simply, which is enough. Don't need to put any additional words. Simpliciter judgment, simple judgment, no need of any addition, without any addition. Scienter means doing something knowingly, deliberately, being aware of something, even after that doing something deliberately or knowingly, even after aware of the circumstances. I know that if I will touch the electricity, bare electricity wire, I will get electric shock, even after I touched that. So I did that deliberately. That is scienter. Scienter means doing something deliberately, even after knowing the consequence, even after being aware of the circumstances, doing something knowingly or deliberately to injure someone, to bring damage to something or someone. That is known as scienter. It is a wrong thing. Sine qua non. Sine qua non means essential condition or most essential condition for a case or a suit. Sine qua non. Like if you want to file a case of tort, injury should be there. Even if damage is not there, injury should be there. Injuria sine damnum. So injury is an essential condition in order to file a case for tort. So any essential condition without which the court will not accept the case, that is known as sine qua non. Indispensable condition, essential condition, most important condition. Next is situs. Situs means position, situation, location. Suo moto means yourself, voluntarily. I did this suo moto. Suo moto means myself. Court started this proceeding suo moto. Means nobody filed this case in the court started this case suo moto. Means by itself, voluntarily, on its own action. Next is stare decisis. Stare decisis means Precedent judgment, literally let the decision stand. To stand or abide by things which is already decided. Lower court has to bind by the judgment of the higher court. See, if high court or supreme court give any decision now, that become a benchmark. High court or supreme court give any decision, that become a benchmark. And if lower court is deciding a similar case, it has to give respect to the judgment of the higher court, and those earlier judgment of higher court is known as precedent. So you have to abide by the precedent. You have to abide, lower court has to abide by the judgment of the precedent, by the precedent or by the judgment of the higher court. That is known as stare decisions. Means you have to abide by the earlier decisions, precedent. You have to literally let the decision stand, let the decision, earlier decision of higher court stand. That is stare diseases. Stare diseases. Diseases means decision. Stare means stand. Let the decision stand. Sign die means without date. Die means date. We have already done before. Die has come before. Die has come before. Die means date. Signed die means without date. So let's say today we have meeting. Let's say today we are not able to complete our syllabus. That will not happen. Today is our last class. So let's say today we are not able to complete our syllabus, and I say you our meeting is adjourned. Signed die. I don't know when I will hold our when I will hold your next class. Whenever I want, I will hold your next class. So our meeting is adjourned on some day which is not yet decided. Date is not yet decided. It can be any day, any future date which is not mentioned. Then our meeting is adjourned. Signed die means without any date. Signed die means without any date, without mentioning any date. Example, meeting is adjourned. Signed die. Our today's meeting is adjourned. Signed die, which means I have not given any date that when will our next meeting happen. That is signed die. Next is proxious preparatories, means preparatory records. Preparatory records means when you are doing something, you make some documentary records. You make some documentary, while making financial statements, journal entry, ledger, trial balance are preparatory records. Means while doing something, you make documentary records. Those records while making something is known as preparatory records, or Trovex preparatories. Totem we have already done. Civil wrong, which is tort, we have done a whole chapter in this. Ubrime fiti we have already done in Indian Contract Act. Ubrime fiti means contract of utmost faith. Right. Remember we studied that silence is fraud. Kya? Mere silence is not fraud. But in contracts of ubrime fidi, mere silence is fraud, because in contract of ubrime fidi, it's your duty to speak. Contract of utmost good faith, bharose, trust, contract of trust, that is ubrime fidi. Next is ubi just imi remedium. This we have done in constitution. Where there is a right, there is a remedy. And because of this, we had section 30, article 32 in our constitution, that since we have legal right, we have remedy also. We have section 32 also, that if our fundamental right is infringed, then we can file a writ petition under section, under article 32. So ubi just imi remedium. Where there is a right, there is a remedy. We are already done this. Ultra virus I have already told you, beyond the power. Next is ut lit pendium pendit nihil innovator. It means during the pendency of litigation, if a case is already pending, court will not accept anything new. Court will not accept any new case. Let's say I have filed a case, I want three relief. I have find three I have I want three relief, and I want three relief. Now later on I am asking court, I want one more relief also. Will court entertain that? No. During the pendency of case, court will, nothing new can be introduced. That is known as ut lit pendente nihil innovate. Innovate means nothing new. Pendente means pending. So ut lit pending nihil innovate means nothing new can be introduced during the pendency of litigation. Next is usufructuary. Usufructuary means when you get right to use someone else's property, that is known as usufructuary. If you use someone else's property legally, they have given you right, but you don't have ownership. Example, I have taken loan from SBI, and I said SBI that if I don't get loan, you can lien my property, you can take my property if I don't repay my loan. So if I don't repay my loan, uh, bank can exercise more lien on my property. Then that will be said that usufructuary, and for the time being, bank is using that property. So here bank is using that property legally, not illegally. Bank has right, because I have given bank right that if I do not pay loan, use my property. So your bank is using my property legally, but is the bank owner? No, I am the owner. So when you are using someone else's property legally, they have given you right to use that property, but you are not the owner of that property. That is known as usufructuary. Usufructuary means you are using someone else's property. They have given you right, but you are not the owner. That is usufructuary. Next is ut res magis velet quem period, means the word of the statute must be construed so as to give a reasonable meaning. Let's say a word is used in a law. Statute means law. Statute means law. 18%. Statute means law. If any particular word used in a law is not clear, it is giving two meaning. It is giving ambiguous. It is ambiguous. It is giving two meaning. One meaning is reasonable, another meaning is not reasonable. So obviously you will interpret it in a reasonable manner. In a reasonable manner. Understood? Like there are some words which have multiple meaning, and we take that meaning which is relevant for our case. Remember, like, are you getting me? There some words have two meaning, and if we are using in a particular context, obviously we use that meaning which is related to the context. So sometimes law some words are used which have unclear meaning, which have two meaning. One meaning is reasonable, one meaning is not reasonable. So obviously you have to interpret. Construe means interpret. You have to interpret law in such a way to give reasonable meaning rather than illogical meaning. You have to interpret law in such a way to give it a reasonable meaning. Next is vis major, force major, vis major. Remember, vis major, act of God. I've already discussed this. Next is vigilant, non dormentius, jara, sub valiant, means law protects only those who are vigilant. Law does not protect lazy. What does this mean? That if let's say there's a fire happening in your house. Someone example, someone in front of you, someone brought kerosene oil, someone put kerosene oil in your house, and in front of you he put your house in fire, and you are just standing and watching. You did not take, you did not even try to stop that person. You did not even try to stop that person. Will court protect you? Court will not even entertain your case. Why? Even if court know that person has put your house on fire, even though court cannot take action. Why? Law helps only those who are vigilant and not those who are lazy. You yourself was not taking action while he was firing your house. So you yourself was not taking any action. You was just standing and watching. So here you yourself was not vigilant. You cannot take action in court of law. If you would have taken action, if you were vigilant, you could have stopped that person from putting a fire to your house. So if you are vigilant, then only you can take law. So law helps only those who are vigilant. Law does not help those who are slumber or lazy. That is vigilant bus. See here, you don't even have to study this. The name itself, vigilant. If vigilant comes, you will automatically understand vigilant. You will automatically able to choose the right answer, right? So vigilant, Bastian, non dormentius, jara, subient. So most of the legal maxim are such that some words in the legal maxim is depicting its meaning clearly. Only few legal maxim are very confusing, whose meaning is not very clear. But see here, vigilant. Automatically you will understand. If in four option, one option as vigilant, then that is the correct answer. Are you understanding? Just by that this word, you will be able to choose the right answer. So that is why I'm telling you, some legal maxims are so easy that by the name itself, you will, by linking one word, you would be able to choose the right answer. So don't take headache. Only few legal maxim are very confusing. Otherwise, it's easy. Vice versa means just opposite, on the other way around. Vice versa. Vice versa. Damnum sine injuria is vice versa of damnum sine injuria. Damnum sine injuria is vice versa of injuria sine damnum. Just opposite, reversed. Voluntary non-fit injuria we have already done in tort. Damage suffered by consent gives no cause of action. If you give your consent, slap me, then you cannot take action. Voluntary not fit injuria, if damage is caused with your consent, you cannot take any action. That is voluntary not fit injuria. With this, we are finally done with all the legal maxims of your chapter number 5, legal maxim. Congratulations, I'm very happy. Let me have water. You also have water. Okay. So, ma'am, now what is left in this chapter? Nothing is left. This is nothing new. This is something which we have already studied. So, what is this? I'll just give you a briefing. We don't have to do all this question because it's not possible that the same question will come in your exam. This is just like uh, logical reasoning. In logical reasoning, you can just understand the concept, how to solve number questions, how to solve alphabet question, how to solve clock calendar question. But the same question might not come. The exact question can be different in logical reasoning, right? So this is similar. I will just explain you how to solve this kind of question. Legal reasoning question, there is nothing new in this. There's nothing new in this question. In this particular topic is from your Indian constitution, from your contract act, from your law of tort, and from your company law chapter. So, for solving this question, you will need knowledge of constitution, contract act, torts, and company law. And have you completed all this chapter? Yes, we have already completed Constitution, Contract Act, Tort, and Company Law. So, in this legal reasoning topic, nothing new is there. You don't have to study anything new. Just some brain question are asked. This logical reasoning. Logical reasoning is brain now. You have to apply your brain. You have to apply your brain. Similarly, some brain questions will be asked based on your chapters of Constitution, Contract Act, Law of Torts, and Element of Company Law. I'll just guide you how this question will be asked. These are very easy, very easy. You would be able to solve it very easily. I'll just guide you. Come here. Ma'am, we are done with legal maxims. 5 pages legal maxim are there. We are done with legal maxim. Just remind me to send this PDF in the group. I will send you this PDF. And we are left with the last topic, that is legal reasoning. It will not take more than 10-15 minutes. Legal maxim. See, legal reasoning. In legal reasoning, what is reasoning? You have to apply your brain. A logical reasoning, you have to apply your brain. You have to give reason. Legal reasoning. So in this legal reasoning topic, some law will be given and some situation will be given, and you have to apply your brain, and you have to derive to a conclusion. Example, I give you law that a contract without consideration is void. This is law. Yes. Where it is given? It is given in Indian Contract Act. So if I say you a contract without consideration is void. Now 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 this is the law. This is law. I told you one law. I told you one law. Now I'm telling you a fact. I'm telling you a fact that I am teaching in YouTube for free. I claimed in YouTube for free that I will teach whole CS executive for free in YouTube. Now I showed you one fact. I gave you one fact. Now, on by applying the law, you have to give a conclusion. Uh, four option, four option. If I don't teach, they can take action against me. Students can sue me. If I don't teach, students can sue me because there is the contract. Option number two. If I don't teach, student cannot take any action against me because there is no consideration. So that is why there is no contract. Two option are given. Two conclusion are given. Two conclusion are given. What you have to do? You have to apply law. What is the law? If there is no consideration, there is no contract. This is the law. You have to apply this law in the fact, and you have to tell which conclusion is correct. Which conclusion is correct? Option A is correct or option B is correct? Tell me. Option A, student can sue me if I don't teach because I claimed over YouTube that I will teach for free. I will teach whole CS executive. Option number B, they cannot take any action against me because they cannot take any action against me because there is no consideration, no contract. Tell me which option is correct. Yes, everybody. Meghna, Pooja, Varsha, Aarti, Disha, Vega, Sohan. Everybody tell, everybody. Yes, I got two answers. Parvati is saying option number B. Meghna is saying option number B. Pooja is saying option number B. Yes, option number B is correct. So how you did? Has anybody taught you this? No, you already know Indian Contract Act. Sohan is also saying B. Okay, correct. So you already know Indian Contract Act. You already know. You just have to apply your brain. You just have to. This is like case law solving. This is like case law solving. Law will be given to you. On the basis of that fact will be given to you. You have to apply that law in the fact, and you have to give the conclusion. Four option will be there. You have to tell which conclusion is correct. So I cannot teach this. I cannot teach this. This is not something new. These are some logical reasoning question. Logical reasoning based on your knowledge of Constitution, Contract Act, law of torts and element of company law. In order to solve this chapter, you should be you should be having proper knowledge of constitution, contract act, law of tort, and element of company law. Like, let's read some example. Let's read some example. One or two example we will read, that's it. Okay, so some legal law is given, and don't apply your extra brain. Don't apply your extra brain, apply only this particular law which is given here. Okay, some law is given. What law is given? All citizens have the right to freedom of speech and expression, where it is article 19. Remember article 19, freedom of speech and expression. So here one law is given that all citizen, every citizen have right to freedom of speech and expression under article 19 of constitution of India, and it is our fundamental right. Don't apply any other law. Don't apply your extra brain. Apply only this law to the fact. Are you understanding what I'm trying to say? Don't apply your extra brain. Don't apply any other law. Apply only this particular law which is given in the question. Now you have understood this law? Yes. Now let's read the fact. Let's read the fact. What is the fact? The fact is Mr. Sinha, a famous English writer and orator, criticized other novelist Mr. Rahul, stating that the novel of Mr. Rahul is very irritational and indecent. His mind is impure. He is loose character. He should write decent and good novel. Mr. Sinha is writing all this thing about Mr. Rahul, that he is not good person, he is irrational, he write indecent, he should write decent thing. So a fact is given. Now you have to apply this law in this fact, and you have to decide which of these four conclusion is correct. You have to decide. First, can Mr. Rahul be sued for defamation? Sorry, Mr. Sinha. Is he doing defamation? First option, he is not liable because he has just expressed his personal views. For a timing, I'll just hide myself so that you can read the option. Second option, he is liable to be sued for defamation if his statement was not true and said with malified intention. Third option, he cannot be liable because he has fundamental right to freedom of speech and expression. Fourth option, he cannot be sued because both are writer and novelist and both can criticize each other. Tell me which one is the right answer. Apply your brain and tell me which one is the right answer. Vega is saying C. Yes. Any other person? Parvati is saying C. Meghana is also saying C. Any other answer? Any other answer? Varsha is also saying C. Okay. Okay. So I'm getting a lot of answers C. Yes, the correct answer is C. And why ma'am C? See, although there is defamation, I agree. I agree. This is defamation. If Mr. Sinha is having a bad intention about Mr. Rahul, if he is having a bad intention, and just because he has personal quarrel, personal envy with Rahul, that's why he's saying wrong thing about Rahul. So can this come under defamation? I agree. I agree. This, second point is also correct. Ideally, the second point is also correct, that if his statement is not true and if he is making the statement with malified intention, he can be liable for defamation. He can be held liable for defamation. So according to Indian Contract Act, this is also correct. According to Indian Contract Act, B answer is also correct. But that's what I'm trying to tell you. Don't apply your extra knowledge. Apply only this particular law which is given in the question. Apply only this legal principle. And by applying only this legal principle, give the conclusion. What was the legal principle? Every citizen has freedom of speech and expression. So since by applying this principle, don't you think that Mr. Sinha has freedom of speech and expression and he can speak whatever he wants? So he can speak this thing. So that is why he cannot be held liable, because he has freedom of speech and expression. If we would refer Indian Contract Act now, then this B point would also be correct. But we are not referring to Indian Contract Act. We have to apply only this law which is given in question. Are you understanding what I'm trying to say? So is this something new? No, this is not something new. Here you just have to apply your brain. And you have to apply your knowledge of Indian Constitution, Contract Act, Law of Torts, and element of company law to solve this particular legal reasoning question. Let's refer one more case and then we will sum up the class. And there is nothing more to teach in this. You can just apply your brain. See here, I cannot teach you this. You have to apply your brain and you have to solve this. I taught you how to apply your brain, how to think, and how to solve this question. You have to apply your own brain and solve this question. In case you don't understand any particular question, you can ask me over Telegram. I always welcome doubts, always. You can ask me over Telegram. I taught you the concept of this legal reasoning, how to solve this question. One more question we will take, and after that we will sum up the class. Legal principle is given. What is a legal principle? A contract is an agreement which a law will enforce. What is a contract? A binding agreement. All agreements are contract if they are made with free consent of parties who are competent to contract for a lawful consideration with a lawful object. A contract is valid if it is made with the free consent of parties, if there is lawful consideration, parties are competent to contract, and they are having lawful object. Have we studied this in Indian Contract Act? Yes. So it is referring about the valid contract. In order to form a valid contract, there should be free consent of parties. They should be competent to contract. There should be lawful consideration, lawful object. Where it is written, ma'am? Section 10 of Indian Contract Act. If you would remember, Section 10 of Indian Contract. This is your legal principle. Now you have to apply this principle in a situation, and you have to tell the conclusion. What is the factual situation? There is a case, there is a situation. Mr. Raja offered to buy Mr. Ram's car for 5 lakh. So here this is Raja, this is Ram. Ram had a car. Ram had a car. Raja offered to purchase Ram's car for 5 lakh rupees. Are you understanding the situation? Raja offered Ram to purchase his car for 5 lakh rupees. But Ram refused. Ram denied. Ram denied, I won't sell my car. Subsequently, Mr. Raja threatened to kill Mr. Ram. Mr. Raja said, I will kill you. I will kill you if you will not sell your car. I will kill you if you will not sell your car. And Mr. Ram agreed to sell the car. Mr. Ram subsequently resigned the contract. But later on, once he agreed to sell the car because Mr. Raja threatened to kill him, so Mr. Ram agreed. Later on, he resigned the contract. Now, Mr. Raja sued to enforce the contract. Now, Mr. Raja went to court. Mr. Raja filed a case in the court and said that there was a contract between me and Ram. He said that he will sell his car to me, but later on he denied. This is the situation. This is the situation. You have to apply this law in this situation, and you have to tell which conclusion is correct. Can you tell me the conclusion? Who is right? Who will win? Raja will win or Ram will win? Can you tell me who will succeed, Raja or Ram? Can you tell me who will win? Raja will win or Ram will win? Yes, everybody's saying Ram. Very nice, very nice. You have understood this. Let's see the four option. Tell me which one is the correct answer. Okay, promptly tell me, tell me. Let's say who said fast. Mr. Raja will succeed. Here, read all the options along with this line. Okay, Mr. Raja suit to enforce will succeed because Raja was offering lawful consideration to the car. This is option number one. Option number two. Option number two. Option number two. Mr. Raja will succeed because buying and selling of the car is lawful. Option number three. Mr. Raja will succeed because both the parties are capacity to contract. Option number four. Mr. Raja will fail because Ram was forced to agree the contract. Tell me which one is correct. Yes, everybody is saying option number D. Yes. So here option number D is the correct answer. I'm assuming that you are saying this by applying your brain and not just by saying the bookish answer. So here, have you understood what kind of question in the legal reasoning will be asked and how you have to solve it? Nothing new is there in this question. This question are based on your knowledge of Constitution, Contract Act, Law of Torts, and those chapters, those legal chapter, company law. So you just have to apply your brain. This you have to solve on your own by applying your brain. In case you don't understand any particular question, you can ask me. So how you have to solve legal reasoning question? A law will be given, and please apply only that law which is given in the question. Don't apply any extra law on the basis of your general knowledge. Okay, don't apply your extra brain. Don't apply your extra brain. Apply only that law which is given in the question. So a legal principle will be given, and situation will be given. You have to apply this law in this situation, and you have to decide which conclusion is correct. Basically, these are very laddu question you would be able to solve. This is your legal reasoning. So how many questions are there? There are, I guess, 20. 21 questions are there. Two questions we have already done. So remaining 18 questions are there. This you have to solve on your own. I have taught you how to solve. How to solve. Legal law will be given. Situation will be given. You have to apply the law in this situation, and you have to decide which among these four option is correct. So I would say you please cross the answer, and when you are solving, apply your brain without seeing the bookish answer. Okay. So what you do, write all the answer in a copy and cut all the answer of the book, so that while you will be solving this now, your the answer will not come to your eye. Okay. So with this, we are finally done with our legal aptitude syllabus 100%. We are done with the remaining topic of Indian Contract Act also, and we are done with legal maxims also. So 100% we are done with legal aptitude, we are done with communication, and we are done with business environment. I hope I justified the lectures and you understood what I taught you. It was my classes. This classes was beneficial for you, and yeah. Now it's time to work hard, madam. Now it's time to work hard. Yes, in case of any feedbacks are most welcome. In case of any feedbacks about my teaching, about class, most welcome feedbacks. In case you want to say, ma'am, this thing was not properly done in class, this topic was not properly done in class, any feedback, any criticism, any feedback is most welcome. It will definitely help me improve my future classes, right? So one thing, ma'am, it's time, it's high time, it's time to make some sacrifices. It's time to sacrifice other happiness for time being. Only few days are left to your exam. Like, how many days are left to your exam? 11 days, 12 days of October, and your exam is in 12th, right? 12 days of September, October, and 11 days of September, sorry, November. 11 days, so 12 plus 11, 23 days. You just have 23 days. You just have 23 days left for your exam. It's very high time. Make your target. Please make your daily targets, that today I have to do this much, tomorrow I have to do this much. Your next 23 days should be properly planned. Without planning, outcome is not good. So do proper planning. Plan properly. Your next 23 days should be planned. By this time I should complete this subject, by this time I should complete this subject, and this time next 3 to 4 days I have to do revision. Plan your day. Without planning, you might not be able to prepare well. Planning is important, preparation is important. If your preparation is good, your exam will definitely be good. So prepare well, and don't waste even a single day. Now it's time to sacrifice every other thing. It's time, this 23 days, please work hard. If you have option to go out with your friends and party and study, please choose study. It's just a matter of 23 days. You will cherish this. You will cherish this later, because just 23, even if you start today, even if you get serious today, I'm telling you, you would be able to clear your exam. You just have to get serious today. Just 23 days of hard work, and you would be able to clear your exam. Don't waste this time, otherwise you'll regret that I wish I had studied a little bit more. I would not have wasted my 3 to 4 months. I would not have wasted my next 2 to 3 months. So please utilize this time. It's high time. It's high time. Be very serious. Now study, increase your study hours, give more time to study. Don't focus more on college. College is on daily basis. Focus more on your studies. College will be daily, right? So focus more on your studies. Your exams are very near. In case of any doubt, any motivation, any personal guidance, any technical guidance, I'm just one ping away. You can just ping me for anything, and I'll definitely be there for any doubt, for anything. Right? I will miss you all. I will miss you all. I will miss your classes. And I hope you will also miss me. Okay. So with this, we are in happy Diwali in advance. Happy Diwali. Ah, Diwali will come every year. I'm telling you. Diwali will come every year. Your exam will not come every year. Once gone is gone. So spend very less time in Diwali. Don't waste your whole day in Diwali. Even on the day of Diwali, just at night, take out 1 2 2 3 hours for puja and relatives. other time in the morning time, and other time give it to your studies. Don't waste your whole day in Diwali. See, students also have their exam in November. They are also having exam in mid of just after Diwali. They also sacrifice their Diwali for their exam. You also have to do that. You have to sacrifice your Diwali for exam. I'm not saying completely sacrifice. Yeah, give time to Diwali, but maintain a balance. It's not like it's Diwali day, I will not study, your bhai will not study. No, don't do that like that. Take out 2 3 hours, 3 4 hours for Diwali. Other time should be for studies. So maintain a proper balance between that. Diwali will come every year. Once attempt is wasted, regret will be forever. So don't do that. Utilize your remaining time, 23 days, very properly. Plan your each and every day. Make a plan, take a copy, take an index of all the syllabus. Plan your remaining 23 days properly. Yes, yes. Thank you so much, Sohan. Okay, happy Diwali to everyone in advance. With this, we are summing up with our today's class. In case of any feedback, I'm always there. I'm all ears for any feedback. And in case of any support for any stage of your CS life, any personal motivation also you need, you can just contact me very freely, like your elder sister. Okay, I'll always be there. I'll always be there. Yes, yes, yes. Thank you so much. Thank you, Pooja. Thank you, Pooja, for such heartwarming message. For such heartwarming message. Yes, thank you, Parvati. Thank you, thank you, thank you, people. Thank you, everyone. Thank you, everyone. I will miss you too, Vega. I will miss you too, Vega. Yes, I will miss you all. Yes, I'll see you in executive. And you have to promise yourself and you have to promise me that, ma'am, we will come in executive and we'll meet you in executive. You have to promise me that, ma'am, we will come in executive. We'll see you in executive. Promise me.